And I look forward to hearing that evidence from the government. Kia ora.
Speaker.
I call the Honourable Leanne Dalzell.
Thank you, Mr. Speaker. I just wish to traverse in the third reading the sequence of events that brought us to today with respect to this bill. The first starting point for this, of course, is the Police Act 1958, Section 57.3, which states if the person in respect of whom particulars have been taken under this section is acquitted, the particulars shall be forthwith destroyed, provided that this subsection shall not apply if the person is acquitted on account of his insanity or is discharged under Section 19 of the Criminal Justice Act 1985 or Section 347 of the Crimes Act 1967. This provision, Mr. Speaker, referred to particulars, and the particulars in this case include a person, and of course this was all written in the masculine gender in those days. We didn't have these nice gender-neutral pieces of legislation that we do today, but given the criminal offending statistics, it's probably appropriate for this particular bill, including his photograph, fingerprints, palm prints and footprints. In those days, and may use or cause to be used such reasonable force as may be necessary to secure these particulars. So that has been the law since 1958, and that of course is quite some substantial period of time. And it was timely that the new law, the Policing Act, took effect in 2008. It was 50 years since the previous law was enacted, and yes, there had been a myriad of amendments, and I think the former Minister, the Honourable Annette King, actually highlighted it as more of a patchwork of legislation rather than a complete whole, as the Policing Act 2008 was wont to be. Now, the Policing Act 2008 was a major change in that it modernised the law, but there were certain features of the law that it wished to replicate, but in a modern sense, and not to derogate from it. But some of the language, as we've already heard, had certainly needed to be updated. If the person in respect of whom particulars have been taken under this section is acquitted, the particulars shall be forthwith destroyed. And of course, what that highlighted is that essentially those particulars were kept unless the person was acquitted, and even when the person was acquitted, if it was acquittal as a result of an insanity finding or there was a discharge without conviction, then that exception did not apply, and the material was the particulars were retained. So this law has always been about the police's right to hold on to information that they have collected from people in investigating a charge, but only allowed to retain it on securing of conviction. Now, obviously the law did allow for two instances in the good old days in 1958, actually prior to my birth. They were allowed to keep that in two other circumstances, and that was acquittal on the basis of insanity. And that's because in many cases I've spoken to people who've been the family of victims of murder, for example, of somebody who's been acquitted by reason of insanity, and they find the acquittal actually incredibly difficult to deal with, because of course the person has committed the act, but they're not guilty of the offence because they don't have the mens rea in order to complete the whole in terms of the offence to be committed. So they're not capable of forming the intention and not capable of pleading in the particular case. So in that particular instance, the Parliament of the day decided that it was in the best interest of justice that that information be made available, continue to be able to be retained by the police. And the same is for those discharged without conviction. And we've heard a lot about the discharge without conviction in this House today. But it's simply nonsense to suggest that this somehow undermines the status of a discharge without conviction, because in order to get a discharge without conviction, the facts must be admitted. So the person has to admit that that they undertook the acts complained of, that they committed the offence, and then they are discharged without conviction. It is a get-out-of-jail-free card. It is literally that. And I believe that there has been a complete misunderstanding of the nature of that because the facts are admitted. Now, given that the facts are admitted, the fact that under those circumstances, that would be the only circumstance where the police couldn't retain those particulars, it seems to me that a judge would be less likely to discharge without conviction if they thought that that was going to stop the police from using that information in the future. Well, you know, sometimes when you give somebody a get-out-of-jail-free card, they use it, and other times they don't. And I actually think that a judge might well be mindful of that fact and say, well, I'm not prepared to take that risk, so I'm not going to give that person a discharge without conviction. I think that we should be cautious about following that particular line as proposed by the Māori Party. And then we come to the Policing Act 2008, and really all the Policing Act did that was different was that it actually talked about an alternative resolution being imposed where the person admits to an offence, like diversion. So given that discharge without conviction is admission of offence, and here are some alternative resolutions to be imposed where the person admits to the offence, the same thing now applies in our youth court. And in fact, we have now, as I said in the committee stages, that in the youth court they have a hierarchy of court's responses if the charge against a young person is proved. And all this does is give the court the power to be a little more lenient, perhaps a little more leaning towards an outcome that would be better for the young person's health and well-being, and perhaps maybe leading them off the trajectory, the pathway to crime that they are on at that time. And I think that under those circumstances, there is no question in my mind that there was a sense in the Parliament when this law was passed in 2008 that the alternative resolution area was an area where the police were going to be allowed to retain those identifying particulars. The only reason that we are debating this issue today is because young people have better options available to them through the youth court, and this clause doesn't reference those options. That's it. That's the only reason that we're even debating this today. So it is on that basis, and also on the basis of this one statement in the regulatory impact statement, which I feel does sum it up. There is no evidence of a policy decision during the development of the Policing Act 2008 to reduce the circumstances under which police could retain youth identifying particulars. And the reason that there is no evidence of a policy decision during the development of that Act is because there was no policy decision to reduce the circumstances under which police could retain youth identifying particulars as opposed to any other identifying particulars. And I believe that it is an appropriate use of both this House's time under urgency to pass a law through all of its stages in order to rectify a genuine mistake when there was no policy decision that was upset as a result. Then, for me, it's a pretty straightforward conclusion. The final point that I want to make is this, that I would normally rail against any form of retrospectivity. And yes, I did use the word trillions because it was just the word that came into my head. But the truth is that if this bill had gone to a select committee, then every lawyer that had represented a young person that in any part of the evidence had included fingerprints or mainly fingerprints, because I don't think photographs are generally going to be the reason for the conviction, but generally fingerprints. So if the police have relied on fingerprints as any part of the evidence against a young person, then their lawyer won't be coming to the select committee to tell them how to improve the legislation. They will be going straight to their clients saying, we can get you off. And we may not be able to guarantee that we can get you off, but we've got a jolly good chance because there is no precedent value around this where there is more than one item of evidence. Or where there is only one item of evidence, we may have a better chance. But the truth is that very few of those examples will be in that situation. But I don't think it's a justified use of this country's expensive judicial system to even go down that track. And that's why I support both the retrospectivity and the substance of the changes. They are minor technical amendments to satisfy a mistake that was made in 2008.
I call the